Hello friends and welcome to Unacademy UPSC Current Affairs. Welcome to Current Polity of the Day discussion. So today we will be discussing a very important topic, especially from your mains perspective, that is judicial review versus judicial overreach. What is the difference between judicial review and what is judicial overreach? So let's get started. Okay. Hi Ankit. Hi. Good evening Ankit. I'm good. Thank you. And how are you Ankit? Okay. So let's get started. So current polity of the day, judicial review versus judicial overreach. So this is regarding the new batches that we are starting at Unacademy. So that is for 2021, 2022 and 2023 aspirants, which commences from 25th of January. So the new batches. And these are the details. This is a 6 months batch course, and apart from that we also do have long term batches, that is 1 year and 2 year batches as well. So long term batches are for 1 year and 2 year. Apart from that we also do provide NCERT batches for your prelims examination. All the NCERT syllabus from your prelims perspective will be covered in this batches. And this is regarding the iconic price hike. The iconic subscription fee is to be increased very soon, so you can get the subscription at the earliest, and these are the features available on iconic subscription. So these are the features that are available for iconic subscription, and these are the combo courses, the subscription fee details of combo courses. So for the combo courses, either you can go for an iconic plus the optionals, or you can go for a plus and the optional. So these are the two combo courses available, and these are the details. So Joicy 10 is my referral code. You can use this referral code and you will get an extra 10% discount. So let's get started. Let's first understand what is a current affair. Justice Suryakant said that judicial review a remedy to prevent abuse of special powers. So judicial review is a remedy to prevent the abuse of special powers. Now what is judicial review? Judicial review means that the authority or the power of the Supreme Court or the courts, constitutional courts, the power of Supreme Court or other constitutional courts in the country to review any of the law passed by the Parliament or the legislature. So if any law is passed by the legislature or the Parliament, then the judiciary can oversee that or review that to see that whether it is in whether it is whether it implies the or complies with the constitutional provisions, or whether it is in accordance with the constitutional provisions. This is called judicial review. And also the special powers, if any authority uses special powers, then the judiciary has the authority to see whether this usage of special powers are in accordance with the constitutional provisions. The Supreme Court judge said at the launch of the book, The Law of Emergency Powers, authored by senior advocate A.M. Singhvi and Professor Khagesh Gautam. So, said this. And Justice N.V. Ramana recalled that some members of the Constituent Assembly had observed that emergency provisions are necessary evil aimed at resolving crises identified under the Constitution. So, the Justice N.V. Ramana recalled that some members of the Constituent Assembly was for making of the constitution. Sameen, hi Sameen, good evening Sameen. So Justice N.V. Ramana recalled that some members of the Constituent Assembly had observed that the emergency provisions, that is emergency provisions are a necessary evil aimed at resolving crises identified under the Constitution. He added that remedy undoubtedly lies in overwhelming and extraordinary power of the judicial review vested in every jurisdictional judicial system. So this was said that remedy undoubtedly lies in the overwhelming and extraordinary power of judicial review. So whenever there is a misuse of power, or whenever there is a misuse of any of the provisions of the Constitution, then judicial review is beyond everything, and there is a power for the judicial review which has been vested with the jurisdiction of judicial system to oversee and find a remedy for that. remedy for the misuse of power. Now let's see what is judicial review. So what is the concept of judicial review? It's a doctrine under which the executive and the legislative actions are reviewed by the judiciary. So it's a doctrine. Judicial review is a doctrine under which the executive and the legislative actions are reviewed by the judiciary. So executive means the Council of Ministers and legislature means the parliament in case of the central government. So whatever actions are taken by legislature and the executive, it can be overseen or it can be reviewed by the judiciary. This is called the doctrine of judicial review. There is it also explains the power of the courts to consider the constitutionality of the acts of organs of government. So there are three organs of government: legislature, executive and the judiciary. So considering these three organs of the government, any act committed by these organs of the government, the courts, the judiciary has the power to see whether they are constitutionally valid or not. Constitutionally valid or not means that whether the act are committed in accordance with the constitutional provisions. This is what is being studied. And declare it unconstitutional if it violates or is inconsistent with the basic principles of the constitution. So in case if the court finds that any of the provisions of the if it is found that any of the provisions are unconstitutional, then the court has the authority to make it null and void. So if it violates, if any action of the organs of the government violates the constitutional provisions, then the court can declare it as null and void. A very good example is NJAC. So NJAC was passed by the parliament as a constitutional amendment act, but the Supreme Court declared it null and void, saying that it affects the independence of judiciary, which is a fundamental feature of the constitution or fundamental principle the constitution follows. So this is judicial review. Now it's a basic structure of the constitution. In Indira Gandhi versus Raj Narayanan case, it was said that judicial review is a basic structure of the constitution. Now what is the speciality of basic structure of constitution? If any of the provisions of the constitution becomes the basic structure, it cannot be amended even using a constitutional amendment act. So basic structure doctrine means that the parliament cannot amend few of the constitutional provisions even using a constitutional amendment act. So such one is the judicial review. It is also called as interpersonal and interpretational and observer role of Indian judiciary. So judicial review is also called the interpretational and observer role of judiciary. Why interpretational? Because judicial review or doctrine of judicial review gives the powers to the courts or the judiciary to interpret any cases or any law. And also observer role. Why observer role? Because Supreme Court or any judiciary will observe the law made in the country, whether it is in accordance with the constitutional provisions. And the power of the legislature to make laws is not absolute. So the legislature is the law making authority. Legislature is law making authority. Now the power of legislature is not absolute. That is, they cannot make laws as and when they feel so. So they do not have absolute right to make the laws, but there are some reasonable restrictions. That is, the validity and the constitutionality of such laws are subject to review by the courts. So the power of legislature to make laws for the country is not absolute, and it is subject to judicial review, or it is subject to review by the courts, which we call as judicial review. Now Article 13(2) of the Indian Constitution, which is Fundamental Rights, Part 3 of the Constitution, Fundamental Rights, says that union or the states, union government or the states shall not make any law that takes away or abridges any of the fundamental rights, and any law made in contravention to the aforementioned mandate shall, to the extent the contravention, be void. So according to Article 13(2) of the Constitution, the Constitution says that the government, state government or the union government cannot make any law which will take away or which will abridge the fundamental right of an individual, because fundamental rights are fundamental to the existence of a person. So no law can be made which will take away the fundamental rights completely, and if any such law is made, it can be made void by the courts. Article 32 provides for judicial review again. It provides citizens the right to directly approach the Supreme Court to seek the remedies against the violation of fundamental rights. Article 32 deals with constitutional remedies in case of violation of fundamental rights. So that is Article 32. It provides for remedies. Third one, the reviews of legislative actions. It implies the power to ensure that the laws passed by the legislature are in compliance with the provisions of the Constitution. So, reviews of legislative actions, it implies the power to ensure that the laws passed by the legislature are in compliance with the provisions of Constitution. And review of administrative actions. It is a tool for enforcing the constitutional discipline over administrative agencies while exercising the powers. So both administrative actions and the legislative actions can be overseen, or it can be looked upon, reviewed by the judiciary. So reviewed by judiciary. Review of judicial decisions. It is seen in Golaknath case, bank nationalization case, Minerva Mills case, Privy Purse abolition case. Review of judicial decisions. That is, the decisions made by the judiciary itself can be reviewed. Suppose Supreme Court passes a order or passes a decree. The Supreme Court itself can look into it again. So the judicial decisions once taken, it can be reviewed again. Now, what is judicial activism? So now coming to the next topic, that is judicial activism. We will see what is the difference between both of them. So judicial activism means an active role taken by judiciary to dispense social justice. So judicial activism means judiciary is becoming proactive. A proactive judiciary in order to ensure social justice. So, in order to dispense social justice, the judiciary is becoming more active. Judicial activism has no constitutional articles to support its origin. So, judicial activism, it does not originate from the Constitution. That means a Constitution does not mention about judicial activism. Suo motu cases, that is the cases that the judiciary takes up by its own, that is suo motu cases. Innovation of the public interest litigation, PIL. Supreme Court can take up cases by its own. Means that even if no party gives a petition in the Supreme Court if so feels that a particular case needed to be taken up, the Supreme Court can take it up. That is suo motu cases. Then innovation of the PIL, public interest litigation. Okay. Then what is public interest litigation? Public interest litigation means in order to consider the larger interest of the public, a case can be taken up. So, discontinuation of principle of locus standi allowed to judiciary to intervene in many public issues. So, all these are examples of judicial activism. Examples: invention of the basic structure doctrine in the Keshavanad Bharati case in 1973 by the Supreme Court further extended the scope of judicial review, incorporation of due process of law instead of procedure established by law, collegium system, then institutionalization of PIL, public interest litigation, banning smoking in public premises based on PIL. So all these are examples of judicial activism in India. So these are some cases where judiciary has been very much active in India, and these examples you can cite when you give your mains answer. So in your mains answer you can definitely quote these examples of judicial activism. So these are some of the examples of judicial activism. Now, what is judicial overreach? Judicial overreach means it occurs when the judicial activism crosses the limit. So, when judicial activism goes beyond a limit, it is called judicial overreach. So, when judicial activism crosses the limit, it is overreach, and it occurs when the judiciary starts interfering with the proper functioning of the legislative or executive organs of the government. So, judicial overreach is when judicial activism crosses the limit, and it occurs when the judiciary starts interfering with the proper functioning of legislative or executive organs of the government. So, in case of India, there is no watertight separation between executive, judiciary, and the legislature. So, there is no watertight separation. So, what happens? Executive definitely has its own jurisdiction, judiciary has its own jurisdiction, and legislature also. So, what is judicial overreach is when the judiciary is interfering into the functioning of the legislature or the executive, and judiciary crosses its own function and enter the legislative and the executive functions. This is called judicial overreach, and this is against the principle of separation of powers. So this is against the principle of separation of powers. What is here separation of powers? Which means that executive, legislature, and judiciary, which are the three organs of government, they have separate powers. This is separation of powers. So this is against or violation of separation of powers. A common example is misusing the power to punish for contempt of court. So misuse of the power to punish for the contempt of court is an example of judicial overreach. Judiciary is overreaching into the jurisdiction of executive and the legislature. I hope it's clear. Judicial activism means active role taken by judiciary to ensure social justice. Judicial overreach means crossing the limit by the judiciary. Judicial review means the doctrine which will allow the judiciary to look into the executive and legislative actions, and this is guaranteed by the constitution to the judiciary. Now, these are the examples of judicial overreach. You can quote these examples when you give a mains answer or an essay. First one, the imposition of national anthem in the cinema halls. This was in case Shyam Narayan Chowdhury versus the Union of India. So this is an example of judicial overreach. Supreme Court struck down NJAT. This is also overreach, which was established through 99th Constitutional Amendment Act on grounds of it being unconstitutional. Allahabad High Court passed an order stating that children of public functionaries or bureaucrats in Uttar Pradesh should be enrolled in only government schools. This is again a judicial overreach. Proactive censorship in case of movie Jolly LLB2 by ordering to cut 4 scenes from the movie, and also directed the CBFC to recertify the film. So these are all examples of overreach. Judiciary is actually getting into the jurisdiction of legislature and the executive. So these are some of the examples. So you can remember at least one or two, maybe national anthem and the UP government, Allahabad High Court passing order that the bureaucrats and functionaries of of UP, they should send their children only to government schools. These are all examples of judicial overreach. So I hope this was a useful session for you. Thank you so much for watching, and today at 9:45 we do have the special class on the Plus platform. Please do come and join me there. Thank you so much for watching. Stay blessed.